FMF Financial Services believes God is calling everyone to take their own stewardship well-done journey. We believe all that we are, all that we possess, and all that we can do is a gift from God, given to accomplish His purposes in the world through us. Simply put, everything we have is provided by God, and we are His stewards. At FMF Financial Services, our mission is to come alongside you and help you manage the resources God has entrusted to your care. The journey of a wise steward includes estate planning and gift planning. You probably don't hear those terms every day. So what exactly do they mean? Estate planning is the process of taking inventory of your assets and identifying the best way to distribute them upon death. Good estate planning will help you maximize your legacy and minimize taxes. It also involves planning ahead by designating who will care for your financial and healthcare needs during a time of incapacity. You've probably heard of some of the most common estate planning tools, such as a will, financial power of attorney, healthcare power of attorney, living will, and revocable living trust. Gift planning is the process of identifying the ministries that resonate with your heart and planning gifts during your lifetime and beyond to enable those ministries to serve long into the future. Identifying the best asset and giving method to maximize impact and reduce taxes are key components of gift planning. Estate planning and gift planning are often combined into a single process that takes inventory of your assets, identifies the people and organizations you love, and establishes a plan to provide for those people and ministries during your lifetime and beyond. So why would FMF Financial Services assist you with the estate and gift planning? It's simple. We firmly believe these processes can benefit everyone, whether you consider yourself rich or poor, or somewhere in between. Wise stewards take care of their families and provide for God's work of redemption and reconciliation on earth. Every gift is important, no matter how large or small. You may not think you have much, but by following God's lead with a willing heart, your gift may be just what a loved one or ministry needs and come at just the right time.
While we don't like to think about it, there may come a time when you are incapacitated and unable to make decisions to care for yourself. Usually, we think of this happening near the end of someone's life, but it can happen at a moment's notice. Thankfully, there are proactive steps you can take to be prepared. First, let's talk about finances. One of the best steps you can take is to sign a general durable power of attorney. This document allows you to name a person to take care of your finances. The document will also list what financial actions your agent may take on your behalf. In most cases, a wide variety of activities are included to essentially allow your agent to do whatever you would normally do to take care of yourself financially. A general durable power of attorney is usually effective as soon as it is signed, so you will want to name an agent you thoroughly trust. Now, let's talk about healthcare. A healthcare power of attorney allows you to choose who will make healthcare decisions on your behalf. In general, this person will only act if you are absolutely unable to communicate in any way, including by blinking your eyes or squeezing a hand. It is also good for you to have a living will. This document tells your doctors and loved ones what heroic life-sustaining measures you would like to be taken or refused. It will also likely address artificial nutrition and hydration and when they may be withheld or withdrawn. Once signed, be sure to keep these documents in a safe, fireproof place. Let your agents know where the originals are located, as well as where you keep a copy that is more accessible. If you are incapacitated and do not have a general durable power of attorney, healthcare power of attorney, or living will, your loved ones may need to go to court to make financial and healthcare decisions for you. This will definitely take more time, effort, and money than simply being prepared by signing these documents now.
A life of stewardship well done includes creating a plan to ensure that your loved ones are well cared for after you're gone. If you don't have a plan, the state where you reside will determine who receives your earthly wealth. Each state has its own formula for distribution. Unfortunately, the state's plan is often very different from what you would choose. A last will and testament and a revocable living trust are two common estate planning instruments. Which one you will use will depend on your assets, beneficiaries, and goals. A will is a signed and witnessed document that describes where you want your property to go when you pass away. Each state has its own rules regarding how to create a valid will. A will is also the place where you will appoint a personal representative or executor to manage the administration of your estate following your death. You can make changes to your will at any time using a document called a codicil. Young parents often first create a will in order to appoint a guardian to care for minor children in their absence. Many people enjoy the simplicity and relatively low cost of creating a will. However, some do not like the fact that wills must go through probate. This is a public process where the court ensures the instructions in your will are followed. Probate takes time and effort and may be costly. If you want to avoid probate, a revocable living trust may be a good option. Unlike a will, a revocable living trust is a private document that's not subject to a probate process. The trust still gives you the opportunity to name a person to handle your affairs when you pass away and includes instructions for the distribution of your estate. While a will only goes into effect after your death, a trust also provides management of your property during your lifetime, including times of incapacity. Typically, you will serve as trustee of your trust during your life and handle your own affairs, much in the same way as without a trust. If you become incapacitated, the trust provides for someone to step in and serve as trustee in your place. The trust also provides for an easy transfer of management when you pass away. The catch with a trust is that it only manages what it owns. It takes a bit more time, effort, and money to properly set up and fund a trust during your lifetime. The payoff is that it should be less cumbersome and costly to administer your estate upon your death. Your loved ones will appreciate the time and effort you put in during your lifetime to make this possible. For estates valued over the current state or federal estate tax exclusion amount, additional provisions can be included in a trust for married couples to maximize savings and reduce estate taxes. Gifts to ministry can also be structured to greatly reduce taxes. Whether you choose a will or a revocable living trust to provide for your loved ones, there are a number of ways you can continue the stewardship you practice during your lifetime, and also include provisions for ministry involved in God's kingdom work on earth. One of the easiest ways to accomplish this is through a bequest. Special language can be incorporated into your will or trust, making a gift to a particular ministry of a specific asset, a specific dollar amount, a percentage of your estate, or the residue of your estate after all other gifts have been made. In addition to your loved ones, your local church, annual conference, world missions, child sponsorship program, Christian university, or any number of human service ministries would be blessed to receive a gift upon your death.
Many people do not like the thought of their assets going through probate in order to be distributed to their loved ones. That is why many people create a revocable living trust. However, there are a few tools available to you in addition to the trust. First, if an asset allows, you can name someone to be a joint owner of that asset with you. This is commonly used by husbands and wives for bank accounts and real property. When the first owner passes away, the remaining owner will continue to own the asset without the involvement of the court. Joint ownership can work well, but there are some pitfalls to be aware of. The other joint owner on the account is a full owner and, as such, could withdraw the entire amount. Also, if the joint owner divorces or is sued, the joint account may become subject to a divorce or lawsuit settlement. Many times, a single parent will name one of their children as a joint owner with the intent that the child will distribute the account equally to all children. However, the child who is the joint owner may legally be able to keep the entire amount and not honor the wishes of the parent. Accounts with a beneficiary designation will also avoid probate. This is fairly common for retirement accounts and life insurance. Some bank accounts allow this as well. When all owners of the account pass away, the named beneficiary will receive the asset. In many cases, you can name more than one beneficiary, such as naming all of your children to receive equal shares. It is also possible for you to name a ministry you love to receive a percentage. Just as with joint ownership, it is never a good idea to just name one child and expect that child to share with others. Legally, the asset would likely belong to the one child named. But what if a beneficiary passes away before you? Some accounts allow for a contingent beneficiary to be named. Others may follow a specific set of company procedures that may involve probate. What happens if the person you name as beneficiary is a minor? Beneficiary designations generally do not allow you to specify someone to serve as custodian for the funds or state a particular age for the minor to receive the funds. Joint ownership and beneficiary designations can be useful in some specific circumstances with good legal counsel. But as you can see, they can often have unintended consequences. You should not rely solely on joint ownership and beneficiary designations to take care of your entire estate. They should always be coupled with a will or a trust.
Less than half of all Americans have estate planning documents. Even fewer have considered gift planning. For those who do, many of their plans are out of date and do not reflect their current needs. Too many people feel overwhelmed by this important topic and let cost or procrastination get the better of them. We would be happy to walk with you through the estate or gift planning process. We can help you take inventory of your assets and talk through the people and ministries that are important to you. If you have questions along the way, just ask. No question is too big or too small. We love to have conversations that lead to just the right plan for you. And we've worked with attorneys to provide documents to you below market cost. Don't be overwhelmed. Just give us a call. We'll help you take the next step on your own stewardship well done journey.